It's been 15 years that the Institute of Law, Psychology and Innovative Education has been working. We're very grateful to the organizers for having invited us. Today's discussion on the topic of mediation is extremely relevant. This topic has been discussed for about 10 years already, and there has been a lot of discussions on this topic. But it's for the first time that it happens here with us. So I really wish to have a very active and fruitful discussion today to bring in something new into scientific approach to this topic. And of course, the National Lviv Polytechnic Institute will be happy to know that the great ideas are coming from here. So when we found out that we're going to host this conference, we supported this idea. And today, I truly hope that with the help of our active support, such a very useful discussion will happen. I wish everyone to have a great, fruitful day. And apart from this, I hope our guests will find out more about the history of Lviv Polytechnic National University, about the history of Ukrainian people, about our achievements. I wish everyone a fruitful day. Thank you very much. It was a great welcoming speech, and now we would like to give the floor to Petro Kucik, the Doctor of Economics, Professor Rector with University of Trade and Economics. Glory to Ukraine. We start with this welcoming word all our discussions. Because we have Ukraine, we have our state, we still can be the citizens that are moving forward and setting up trends to the modern world. Those are not my words; those are words of the graduate of our university, Stepan Bandera. Now, today we are happy to host this big scientific and educational forum. Today we're going to discuss mediation. But all those are the components of the educational environment, the development in education. We clearly see right now that education is a lifelong process. If we're talking about a person who wants to achieve something, this is a person that achieves and develops. So everyone who present at this conference today will have the possibility to hear the thoughts of scientists about mediation. There will be nothing new because mediation for university is something like an axiom. Even some 700 years ago, there was mediation between professors and students. And within the process of mediation, a lot of things could be solved. And in this case, the universities did a right step forward. The elements of mediation or in the educational components are being introduced into the educational process. The university environment needs mediation, needs some modern dialogue of understanding. Dear students, dear professors, I wish you the fruitful work as to our university, Lviv Trade and Economic University. I would like to say that these elements are being introduced already into our educational process, and our teachers were the initiators. And I would like to thank all of you, and namely Kristina Goretska. So I wish all of you fruitful work. And I hope the Ukrainian Academy of Mediation will be able to be the symbol of the relationships between the university, and we are also very grateful for the Lviv Polytechnic National University for organizing this forum. Glory to Ukraine. Thank you so much. And now we would like to give the floor to Oksana Tsimbarivska, head of the EU project Prava Justice. Hello, everyone. Hello, dear participants of the conference and the organizers. I'm very happy to see um, this place full with people, a lot of students. First of all, I would like to thank to National Lviv Polytechnic University for hosting this event. And I would like to thank the Prague Consent and the colleagues from GIZ, Ukrainian Academy of Mediation, and all the universities who joined for this opportunity to be able to talk about the mediation in universities for the second year in a row. Last year, this conference was held in Chernivtsi, and it's great that we can say right now Mediation in Universities 2.0. It's our second event, and I hope it will open the tradition of discussing the mediation every year, discussing how universities can influence the development of mediation and what is the role of the students in this process. I would like to concentrate on mediation within the context of Euro integration. You all know that Ukraine is undergoing the process of Euro integration, and there is a number of requirements from the European Commission. And there are some recommendations from the Euro Commission regarding mediation as well. 10 days ago, on the 4th of November, the European Committee issued the new report on regarding Ukraine. There were certain recommendations in this report concerning mediation as well. Let me quote them. European Committee says that the level of the implementation of the law on mediation is still insufficient. Ukraine needs national system of data collection and mediation, and the obligatory mediation should be prepared and implemented for specific categories. Or also, they was talking about the development of arbitrary proceedings. All this tells us that Ukraine needs to develop mediation actively. Also, it's kind of an echo to those recommendations that were determined in the roadmap on development and popularization of mediation to make sure we raise awareness among the people of Ukraine, to make sure that students and everyone concerned knows what mediation is, because mediation is the part of effectiveness of the judicial system in Ukraine and access to justice. And the role of students and young people in this process is very important, because after some years you will start working in the systems, and you have to understand that the first step is not the court but mediation or some other alternatives to the disputes. We as private justice support the development of mediation in Ukraine systematically. We cooperate with the Ministry of Justice in order to assist them with the tasks that are indicated in the roadmap, and to do some progress in the Ukraine EU integration. We are providing the survey on the category of disputes where mediation is possible based on the European experience and some Ukrainian practices. The students, the last message is for you. Now, there are a lot of competitions at the European level, and the competitions on mediation as well. Um, please take part in it, and private justice can support your participation in this kind of competitions. Thank you very much for your attention. Thank you so much, dear Oksana. We also give the floor uh, to Artem Alexandrovich Shipov. The head of the legal and policy advisory team to the project support to Ukraine's EU accession in the rule of law area. Dear colleagues, I'm very happy to be here. I'm grateful to the organizers of this event. Our project of EU accession to Ukraine in the rule of law, which is supported by the Ministry of Foreign Affairs and GIZ, is directed to three main directions of work. Maybe you have seen in the logo, three for you: expertise, experience, and exchange for Ukraine in order to um, give Ukraine more possibilities to EU accession in the rule of law. I'm very happy to take the floor after Oksana because she named a lot of things. She mentioned all the key documents of the European Union, so I don't have to do it. The task of our project is to make sure that our governmental partners and our partners from the universities, from the civil society, get the tools and expertise and experience for the dialogue and experience exchange and implementation of the roadmap, for example, on the rule of law. Mediation indeed plays a crucial role at several levels, and I would like to briefly outline those levels. It's the level Ukraine, European Union. Mediation is the part of the roadmap events on the rule of law, and fulfilling those tasks approximates Ukraine to the membership in the European Union. Mediation also is the part of the processes that ensure justice in the society, and it's very important for us to discuss the interaction between mediation and the judiciary system today, how mediation can help the citizens, can help the judiciary system to solve the disputes in the civilized way and de-escalate the conflicts. Also, we are going to discuss mediation in universities and work with future generations. I'm very happy to see a lot of students today, and they will have the opportunity to hear a lot of useful things from their experienced colleagues on how the mediation can be used, what are the tools, what are the best practices, and thus we can make sure that future experts in law will have the skills in using these tools. Our project will continue to support Ukraine and our partners from the government, civil society, and academia in order to give you possibility to join such events. We're very happy to support such event as today, and we'll be happy to cooperate in the future. I will stay here during the day. And if you have any ideas about interaction with our project, please feel free to contact me. I wish everyone a fruitful discussion. Thank you so much, Artem. And now we would like to give the floor to the president of the Ukrainian Academy of Mediation, head of the EU project Consent, West Ukrainian National University, University of Southampton. PhD in law, Luisa Romanadze. Luisa, please, the floor is yours. Hello, thank you very much. I am very happy to see so many people here today, on both online and offline. And I know that our program is very intense, so I would like to straightforward to jump to our panels and reports. But first of all, of course, I have to thank everyone who made this conference possible today for the second time. First of all, I would like to mention the projects which supported us, Prava Justice Project, EU approximation in the rule of law. Thank you very much for believing in us and mediation and the idea of this conference, because indeed we're very much in need of a platform to discuss the mediation in the academia. Also, I would like to say that this conference is an example of interaction of different stakeholders in order to make sure mediation is developing. This conference is organized by a lot of partners, and we have decided, in order to save time and to make sure we can make a deep dive into the topic of mediation in universities, we did not introduce ourselves, but I would like to mention everyone to make sure that all of you understand how many institutions made this conference possible. It's the National University, Lviv Polytechnic University.
It is the State Trade University. It is the West Ukrainian University. It is the Lviv Polytechnical University. We are extremely grateful to you for providing your premises for the workshops which will take place tomorrow. Lviv Center for Mediation. Mediation service of Yuri Fitkovich University of Chernivtsi, National Technical University named after Sikorsky, Yuri Fitkovich University of Chernivtsi, University of Donetsk named after Vasil Stus, University of Vinnytsia named after Mikhailo Kotsubensky. Thank you very much for your contribution. Thank you for all the organizational meetings that we held in order to make it happen. We have more than 700 pages of handouts. We have so many wonderful speakers today, practicing mediators, lawyers, students, which is great in my opinion. I'm looking forward very much to our joint work today. I wish us all a wonderful day and fruitful work. Let the mediation flourish and develop, and we know that every day the number of those who believe in mediation constantly grows. Thank you very much, dear Luisa. Let us proceed with our first plenary session, with our first panel. I'm giving the floor to the moderators, Ms. Kristina Horecka and Ms. Luisa Romanadze. Thank you very much, dear participants, to the conference. We are starting our first panel entitled Mediation in Action, Scientific Approaches and Practical Solutions. Indeed, mediation is a live instrument today, which is in the first place about trust. That is why mediation in action is a new philosophy today, a new philosophy of mutual understanding, which combines scientific approaches, academic approaches with real practical solutions. This is why it is so strong. This is where its strength lies. I will now give a floor to our esteemed speakers. But before that, let me kindly remind that the time slot for each speaker should not exceed 15 minutes. I'm very honored to give a floor to our first speaker, Virgilius Valančius, Judge of the General Court of the European Union, Senior International Expert at EU Project Level Justice. Can you hear me well? Good morning, dear participants to the conference, dear students in the first place. I'm very honored to be here in this academic environment among students. It make me recall uh, the years that I spent teaching at the university as a professor rather than about my uh, years in the court of justice, about my judicial career in general. Such meetings make me feel younger. Besides, it is always a pleasure to uh, pay attention to a strengthening of uh, higher education, including higher legal education in Ukraine, alongside its core activities aimed at the cooperation with law enforcement authorities, with the prosecution service, with the judicial power, etc. In the meantime, legal education remains in the focus of our attention, especially in terms of uh, enhancing the scope of learning of EU law. As one may have noticed, EU law has its say in various sectors, energy, environment, economy, and so on. Mediation is also something which is governed to a certain extent by the rule of law, by the EU law. Dear students, you are learning EU law. There is a French saying, le jeu en vaut la chandelle, which means that the game is worth candles if you translate it literally into the English language. So this saying comes from old times where people would play a table game which was on the edge of gambling. And since they were playing mostly in the evenings, they needed candles to be burnt in order to be able to be able to play actually. So that is why this saying is used to say that something is worth efforts, expenditures, and so on. So coming back to EU law, after having worked in various judicial institutions, including in the highest judicial institution of the European Union, I realized how important mediation is, and I've become a passionate advocate of mediation. Let us try to examine mediation through the lens of the Euro integration process happening in Ukraine. In May 2025, the Ukrainian government adopted the rule of law roadmap, and in the rule of law roadmap, in accordance with the rule of law roadmap, the Ministry of Justice of Ukraine is expected to examine in the next year the reasonableness of introduction of mandatory mediation in the judicial system. For this purpose, an interagency working group was created, governed by the Ministry of Justice. So this scope of powers of this interagency working group will include, in particular, exploring foreign experience and best practices in order to identify spheres where Ukraine can start introducing mediation. It may be family law, it may be some other types of disputes. If we talk about a pre-trial settlement, I can personally see two options here. The first one going as follows. The parties undergo or attend an onboarding session where they would be informed about mediation and about how it happens. Then they may have a second meeting, which will be dedicated to the mediation as such. And then in the aftermath, if there is common understanding, a judge becomes involved. And then if mediation results in some positive settlement, then the court, the judge, would approve the settlement which was reached. If not, the parties may go before court within a regular procedure. If we look at the example of other countries, at how it happens in other countries, one may notice that the situation is not homogeneous across the countries, even at the European continent. For instance, a Serbian judge would say that mandatory mediation had no future in Serbia because in Serbia, when people go to court, they expect the opposite party to be dismantled, and that is why they are not ready to reach any compromise. At previous time, the situation was very much similar to the one described by the Serbian judge in my country as well, in Lithuania. However, it doesn't mean that we should not apply efforts to change it. Now, if we go back to the European dimension, it is worth saying a few words about the EU as a phenomenon. As you may know, the nature of the EU is quite unique. It's not a federation. It's not an organization, but it is a very unique structure, sui generis, as we say in Latin, which forms a common government structure. This is something that we should be very well aware of, because when Ukraine joins the EU, some of the government powers will be transferred to this supranational level, to the EU level, while other powers will remain within national government. That is why mediation is so much popular in the EU.
If we compare different member states, this question becomes more sophisticated when we get into detail. For example, the balance between obligatory mediation and willful mediation. Whether we can force the conflicting parties to try mediation, this is also a question. Whether the society is ready. Today, I hear a lot that Ukrainian society is not ready, and I was hearing the same things 25 years ago in Lithuania. It's been not the first year since I'm living in Ukraine, and I see a lot of similarities between Lithuanian and Ukrainian societies, indeed. But today, we see that society is changing. Maybe it's due to the influence of European Union or some other processes, but as for me, age society and Ukrainian society as well can be ready for mediation. Sometimes it's difficult indeed because sometimes it's bad because sometimes really people want someone to rule your case and you don't want to take any efforts. But mediation is a possibility, and we this is what is going to be discussed in this council, interdisciplinary council, from the 1st of January 2022 in Lithuania. People have to obligatory use mediation in family cases. If you don't do this, any court won't start ruling your case. You will not be able to submit your documents if you didn't try the mediation before. Also, there is one more important element. Who is going to pay for this obligatory mediation or the information session? In Lithuania, we decided that 8 hours of the obligatory mediation in family cases is paid by the state. It's within the state of the legal assistance granted by the state. So it's something similar to Mr. Baranov's agency in Ukraine. So it's about the money. And I had discussions with colleagues from other countries, and they said that a lot of people, they don't have money to pay for such services, and sometimes they don't understand what mediation is, so they are kind of reluctant and they don't understand why they should pay the money and why they should use it. So the state should step in and help them to enter into the process. and help them to pay for the services. So going back to Lithuania, in the family cases, people are obliged to do the proper mediation, not just an informational session, but mediation. And you cannot move further with your case if this hasn't been done. And your dispute will be blocked at this point.
Some details are more developed in civil or commercial cases. There are very developed elements, and I hope that this is going to be covered today by my colleagues. How much time do I have? I have to finalize here. That's what I heard now. So the ECJ case law, a short intro here. ECJ is the most important institution in the European Union. Do not confuse it with the Strasbourg Court, with the ECTHR. Those are different institutions. The ECJ is based in Luxembourg. That is EU law, the way we understand it. In most cases, is interpreted through case law or through the legal positions or jurisprudence in Luxembourg. When it comes to mediation, there are several cases. 14th June 2018, Medina and Rampanelli case clearly indicates that mediation, pre-court mediation, is okay and it does not contravene the EU law. Another case that's more interesting, a 2024 case, ECJ mentioned that pre-trial mediation, the mandatory mediation, is not in contravention to EU law, even though the Constitutional Court of Romania mentioned that it is in contravention to the Romanian Constitution. We don't have time to cover it in more detail, but to summarize, neither the EU law nor the 2008 directive nor ECJ jurisprudence is in contravention to mediation in general and to the mandatory pre-trial mediation. There is one small nuance here. In all cases, the parties have to have an opportunity to go to court after making use of mediation, after mediation failed. Thank you so much. We thank dear Virgilius for sharing this valuable professional experience. Of course, for Ukraine, the implementation of European standards of mediation is a valuable and good opportunity to make our legal system more flexible and result performance-oriented. We hope that it's a step towards the European future of Ukraine. Thank you. Dear participants, are there any questions to the speakers? If there are, we will accumulate them because of the lack of time, and after our conference, the speakers will answer. Thank you. Thank you. Now we will hear from our next speaker, Jill Galton, who is the consultant to the Ministry of Justice, mediator, researcher, and author. Author, by the way, of an incredible book, Child Inclusion in the Parental Dispute Mediation, confirms that it's extremely valuable, and it has reference to step-by-step analysis of the Goldson model. So Jill is also the director of the Center for Family Matters that is based in Auckland, in New Zealand. Today, Jill will be speaking about listening to the child's lived experience in situations of conflict, what child-inclusive mediation can teach us about justice and healing. The floor is yours.
Thank you, Louisa. And it's a huge privilege for me to be able to attend your conference. And thank you to all of you, my colleagues in the Ukraine. It's the middle of the evening here, and it's a cold spring night, which I'm sure is very different on the other side of the world. I know there's a limited time, and please don't let me talk too much because I tend to do that sometimes. So let me know if I'm going over time. So as Louisa just said, I am the director of the Family Matters Centre here in Auckland, New Zealand. About 10 years ago, mediation was brought into family law in New Zealand, and it is mandatory as long as there is no issue of violence or mental health problems. So we started having mediation in this country about 2014. About this time, I started to research the topic of the inclusion of children in mediation because it became very apparent to me throughout my years as an academic and also as a family therapist that children being part of the family, a very important part of the family, really needed to have an opportunity to be heard and indeed to participate in family mediation. Now, I do have to say this concept was not received well in New Zealand, and it's been a huge project spanning probably 22 years of promoting the need for children to be part of their parents' dispute resolution. I'm very pleased to say that after all that work, all that time, that a law was passed 2 years ago where children are now expected to be part of parental mediation. As Louisa just said, for my sins, I also wrote a book about it. I don't think I'll ever write another one. It was very hard work. It's quite a short book, but I felt it was important to be able to express not just how we do it, but also why I think it's very, very important for children to be involved in mediation. So that's just a tiny little introduction. I think the only other thing to say is that I am the middle child of 3. And I think by the time I was 5, I was already a mediator. So sometimes I think we're born to these things as well as being trained. So this is a short paper really just to talk about what can be learned about the justice and ethics and healing which comes about by listening to the lived experience of children. So in the New Zealand family court system, we do include children in the court process. My argument has always been that rather than represent children through their own lawyer, that a much more informal but very professional process can take place where children talk to the mediator, which is what we call the Goldson model now. And the mediator is able to talk to the parents about how their child is managing in a situation of quite intense parental conflict. So I just want to stress very quickly that we don't have child participation in order for the children to have to experience the burden of choice. but more to talk about how they are experiencing the conflict between their parents. So by including children safely and compassionately, the children's participation can transform the whole narrative of separation, of ruptured attachments and conflict into one of recognition, empathy, and relational recovery. One of the things that's really driven my work in this capacity is that children can become extremely psychologically ill when they're caught up in parental conflict. We also know that by the time parental disputes get into the court system, that the disputes are very, very high conflict. And we do know that 25%, which would be a conservative estimate, 25% of children who go through the family court go on to develop a formal mental health diagnosis. So I actually see this work as a public health issue. Now, I'm very aware that my practice is with children in domestic family conflict, not in war zones. The principles are universal in my view because children span all contexts. And I think it's a given that parents and children parents as well as children need to be able to talk about their lived experience and to be heard. When we listen, people will talk. And when people talk safely and feel safe in their conversations, the results can be liberating. William Shakespeare, the British bard in the 1500s, has a very good quote about being able to talk. And he said, "Give sorrow words, the grief that does not speak knits up the o'er-fraught heart and bids it break." And I think that we all know when we want to say something and it's really, really important to us and nobody is able to hear us or listen to us, the grief compounds and the distress gets worse. John Bowlby, who I'm sure many of you have heard of, who lived from 1907 to 1990, was a British psychiatrist, and he taught us that attachment, child attachment, is a biological imperative, which is as important in many ways as food and shelter. We know that early relationships for children with their families shape their brain development, their ability to have resilience, their emotional regulation, and later on their parenting. And we do know that children tend to follow patterns. The patterns that they experienced as children, they are likely to demonstrate when they are adults and parents themselves. One of the many benefits of child inclusion is that children actually see their parents experiencing mediation. And it's a very, very good piece of role modeling for children because when they're adults and they're in conflict, they can recall, well, this is what my mum and dad did or my grandmother did with my parents. About a year ago, a young man of 25 rang me up because he was experiencing his first heartbreak. He was a young man I saw when he was 7 years old and was a child who talked to me about the difficulties he was having in his parents' conflictual situation. And I thought it was very, very positive that he had remembered all those years and had wanted to talk about his distress. So two things I want to say really. One is that children are dramatically assisted to manage conflict in their lives if they are assisted by careful facilitation. And the other thing I want to say is that when parents hear what is happening for their children, it will often go a long way to helping them to lower the conflict and to reach agreements that otherwise they were struggling to reach. So I'll just give a very, very brief case study. A little boy came to see me when he was 9. He was in and out of hospital with tummy pains, which were known to be psychological in origin. When I met with him, he said to me his biggest problem in the world was that in his new house, Daddy said he could choose the color of paint for his bedroom wall. And he said, Jill, I don't know what to do because Mummy loves green and Daddy loves blue, and I can't choose a color. Obviously, in the feedback to the parents, I was able to explain that their conflict had impacted their little boy so much that he was unable to have a favorite color as normal children who are not in conflict with family conflict. It was very, very significant for the parents. They didn't go on to live happily ever after, but they dropped the conflict because they could see what the conflict was doing to their child. And they said to this little boy, when they met with him afterwards, look, darling, Mummy loves green and blue. Daddy loves green and blue. We don't mind what color wall you paint. The little boy's relief was palpable. That's just one very, very small case study of how parents hearing their children can drop their conflict and how much better children feel when they can describe their lived experience. And you'll note the difference between a child talking about his experience rather than being asked to choose how much time do I want to spend with my mum, how much time do I want to spend with my dad. So I tend to call this child participation, although it's child inclusion, the act that has now come about, I'm very encouraged to see have used the words I wanted them to use, which is child participation. So whilst I appreciate that my own practice is domestic, of course, I fully recognize the layered pressures on your families in the Ukraine with displacement, separation with parents at war, loss, guardianship disputes, and the intergenerational strains. I do believe that inclusive child participation principles can support families under all forms of pressure. So we do know that when children are safely included, parents are able to communicate far better with one another and also with their children, because when we are stressed as adults, we all revert to being children ourselves. And so if you're a very stressed parent, trying to communicate with your child can be very difficult. Often children don't want to talk to their parents about their worries as children because they don't want to make things more difficult for their parents. But if they're given a facilitated opportunity professionally, it tends to remove the blocks that children and parents are experiencing. The conflict de-escalates, the entrenched positions soften, and children gain stability and relief and a greater trust. We know that children who become separated from wider families, so it's not just about the separation between parents, but it's also about separation from grandparents, for example, cousins, uncles, aunts. This can happen through natural disasters, through war. It can also happen when there is extreme hostility in a dispute in the family, and we have to tackle in this country and in Australia and in Britain something we call parental alienation, which is an extreme, it's an extreme example of high conflict where one parent will try and psychologically erase the other parent so that the child ends up becoming quite poisoned against the other parent. So all of these topics I talk about in the short book that I've written. This is really just what we would call a whistle-stop tour through the topics, and each topic that I'm talking about bears a far longer discussion and also some pragmatics about the best way to professionally practice. Really, just in conclusion, I'd like to say that child inclusive mediation, in the way that I'm describing it, is a vehicle for empathy and relational healing. And whilst mediation is now fully funded in this country as of, I want to say, 3 or 4 months ago, we still don't have as good a take-up as I am hoping we will. The fact that children are now included is something that I'm really needing our Ministry of Justice to send out more information to families. Families still are a little bit confused about child inclusion, thinking that children are going to be in a position to choose between their parents. That isn't the process at all. It's to actually help the parents to find a way forward in the best interests of their children, which is going to work for everybody, because no parent is happy if the children are miserable, and no child is all right if the parents are miserable. So it is a family systems process. Parents often describe the conversations they have in child inclusion as turning points where the insight they get softens the conflict. And never, ever do I, when I train other mediators in this topic, do I ever advocate being judgmental about the conflict parents are in. Nobody wants to get into conflict. No one wants to be in crisis. It happens. And when practitioners are compassionate to parents and children, then in my own practice, we have an extraordinarily high rate of resolution. Just in terms of training, which I do believe is very important, it's like anything that's effective and very good, it doesn't have to be overcomplicated. I think it was Einstein who said, make everything as simple as possible, but no simpler. So I think a succinct and effective and evidence-based training is really important. And it involves family systems work, trauma training, an understanding of child development and attachment, the ability to understand how to listen to children and what safe and simple tools to use. And I think very importantly as well is the opportunity to have professional supervision, either individually or in groups. So just to conclude, hearing the lived experience of children softens conflict and supports resolution. It honours their right to be heard, protected, and connected to their family life. So thank you very much for the privilege of talking to you today. I hope you have a really good day. Thank you.
Thank you very much, Jill, for sharing your experience and for all your efforts to make sure the child voice is in the mediation process of the parents. Thanks a lot. So the next report in our plenary session is from Titana Tsuvina, the Doctor of Law, Head of the Department of Civil Procedure, Arbitration and Private International Law, Yaroslav Mudry National Law University, Head of the Center for Mediation and Alternative Dispute Resolution, international expert of the project, EU accession to yes in the rule of law. And her topic is the development of the institution of mediation within the context of Ukraine accession to EU. I do everything possible to catch up the time. I need the clicker, so let me start once we're trying to solve the issue with the clicker. Speaking about the development of the Mediation Institute in the context of EU accession, some key documents have been mentioned already. The roadmap, the documentation package, the events that should be there in the roadmap. So then could you please change the slides for me? Thank you so much. So we're talking about the mediation within the context of EU accession because the screening of the national law to the EU standards has finished, and there were negotiations regarding the screening on Chapter 23, Justice and Fundamental Rights, Chapter 24, Justice, Freedom and Safety, and the question of mediation was brought up within the context of the Chapter 23, because one of the parts of it is the justice and alternative ways to settlement of disputes, including mediation, and also they were talking about the availability of the justice and access to justice. Also, some other questions regarding trans-border disputes within the context of Chapter 24. There was a chapter on cooperation in court and civil cases. Also, Mr. Verhelius mentioned this today, and it's a very accurate question. So these events that are indicated in the roadmap and improving this roadmap is very important for the first cluster, fundamentals, and the implementation of these events are very important to close this cluster. Further on, it is the first cluster to be open and the second cluster to be closed within the context of negotiation. If we're talking about the roadmap on the rule of law, colleagues mentioned today that there are a lot of events planned, and you have a look at the plan like alternative ways to settle the disputes. Only one event is about the arbitrary process, and the rest of them is about the mediation. Those are campaigns to raise awareness about mediation, also raising capacity of different stakeholders to provide free of charge legal assistance. Also, it is the possibility of implementing the obligatory mediation, as Mr. Vergilius was mentioning. You see there is a number of events dedicated to these questions. Next slide, please. When we are talking about the approximation of the national legislation to EU ACAS, we are talking first of all about the Directive 52 of 2008, and the lawmakers of the law on mediation were taking this directive into account while developing the national law on mediation. We can see that the law reflects the classical facilitation model, and there are the main principles. According to the directives, mediator is a professional who had relevant training. There is no diversification on professional and non-professional mediators. In some countries, they do have this differentiation. Also, it underlines the role of the court on the popularization of mediation and some types of mediation, some, for example, external court annexed mediation and court mediation. Today, I would like to throw the light on some problems, however, and I think we have to think about them in order to improve our legislation. We can talk that the recommendations regarding the implementation of the deeds as the result of the mediation is still something that can be improved. It's not the worst alternative to the court, as we say, and when we say there is no possibility of forced implementation of the deed, it can be the factor that influences the choice of the parties to choose or not mediation. We see that according to the legislation, we can differentiate the possibility of obligatory or forced implementation of the deeds integrated into the court. Here I'm talking about the negotiated settlements, and it can be obligatory. And also there is a number of settlements that cannot be forced. This is the settlements based on the result of the non-integrated, non-court annexed mediation. And here the parties have the possibility to choose. And this question is very important within the context of obligatory models of mediation. When we're talking about obligatory models, then the question is, if based on the results of this mediation, the parties come to the settlement between the court, what will be the consequences of this mediation? If it's equal to the court annexed mediation, which is obligatory, so mediation normally happens before the proceedings. So the question is, what will be the consequence of this deed? In many countries of the European Union, the legislation develops in such a way that it allows the certification of the deeds, even based on the result of the mediation, which was not the part of the court proceedings. So I think we have to give a good think to it as well. This question is also relevant, not only within the context of this directive I was talking about, but also within the context of implementation of Brussels I regulation. According to this regulation, the other EU country can implement the authentic documents or tools. So if according to the Austrian legislation, there was a deed on the external mediation and it could be enforced, and as an authentic tool, it should be implemented also in other countries, EU member countries. So we have to provide as well some tools at the legislative level to make it possible. But there is other dimension. We have signed, but we haven't ratified yet the Singapore Convention. And here I can see some problems. Why? Because EU was not as active and not as active in the question of signing and ratification of Singapore Convention. There are discussions going on whether EU should become the party to this convention, or maybe signing and ratifying of this convention. It's not something that should be done. I am in favor of Singapore Convention, but the fact that we signed it, but we haven't ratified it yet, it's kind of suspended. Creates a lot of questions. So how it correlates with our Euro integration obligations, whether we should rectify it, because there was a working group and a lot of colleagues who are present here today, and myself including. This group was created in 2019, but there has been no active steps after the signing of the convention. Another question I would like to draw your attention to is the confidentiality principle. The directive directly says that there are some from the confidentiality rule, and it's not doesn't correlate in scope with our law about mediation, because we have one exception that refers to other legislation, and another exception concerning the situation when there is a dispute between the mediator and parties. Then the confidentiality principle is not obligatory for adherence in the court proceedings. So we can talk that there is a place to improve the law of Ukraine on the mediation. So also the another question, the term of appeal. So the directive says directly then when the mediation is alternative solution to the court, there should be no other obstacles to go to the court if the mediation was not effective and there was no settlement. Then the proceedings can be stopped. And in our legislation since 2013, it's been reflected in our legislation. However, statute of limitations on going to the mediator is more flexible in this part. Of course, the parties implement it in a different way, but if we're talking about the obligatory mediation, this question also needs some additional attention. And last but not the least, and I'm about to finish because I promised to catch up on the time. So it's other case acts. So we are mostly talking about the directive, but the EU legislation analysis allows us also to talk about other documents that have articles dedicated either to mediation or to some alternative ways to settle the disputes that have to be taken into account while we are talking about the approximation of Ukrainian legislation to EU acquis. This, you can see the list of these documents at the screen. Most of them are not talking about the mediation directly, except for the regulation 1111 that says that the mediation should be used in the disputes about international abduction of children. Regarding the other two documents, the implementation of alternative ways of settlement, like online platforms, for example, is being brought up in the broader context, and mediation can be part of such platforms where there can be some potential for dispute settlements, and it should be analyzed within the context of the approximation of the national legislation to EU acquis. Thank you very much for your attention. Thank you very much, Tatiana, for a very well and structured report on EU accession context, Ukraine EU accession context, and the role of mediation. Thanks a lot. And now, our next speaker, Natia Chitashvili. She's from Georgia. She's a doctor of law, associate professor of the Devakishvili Tbilisi State University, member of the Contemporary Private Law Institute, mediator, executive director of the National Center for Alternative Dispute Resolution, accredited trainer, evaluator of the Georgian Association of Mediators, member of the governing board, and of the Mediation Center of the Metsketa District Court. So she will speak on the regulation of mediation ethics for provider organizations as an expression of mediation social function. This topic is very relevant, especially in the context of the provision of access to the mediation by the providers.
Good morning, everybody. On behalf of Tbilisi State University, Georgia, I'm honored to extend my sincere gratitude to my colleagues, to the organizers of the at most important event, to professional and academic society participating in this important synergy of practice and academy. It's a really great honor for me, and thank you for inviting me to the conference. I think that deep communication to fostering knowledge and collaboration, it's truly a privilege to be here. It's surrounded so many brilliant minds and passionate professionals towards mediation. So as Luisa mentioned, my presentation is dedicated to the topic of regulative policy of mediation ethics of provider organization and why it is the expression of social function of the institution. And this presentation explores the regulation of mediation ethics not merely as a professional procedural requirement, but also as a fundamental expression of mediation social function. Mediation as a liberal and dialogical form of justice is grounded in values of autonomy, trust, cooperation. Its legitimacy, however, depends on the extent to which these values are institutionalized within the structures that administer govern mediation services. Thus, regulation of mediation provider organization ethics represents a normative translation of mediation social mission into concrete institutional forms. The social function of mediation is inherently a relational factor. It aims to transform social conflict into constructive communication and to restore civic trust in justice processes. Unlike adjudication and some confrontational processes, which impose externally defined and strict norms, mediation deprives its authority from mutual understanding, recognition, voluntary consent of the society. Yet, this deliberate balance between autonomy and institutional oversight requires stable ethical guarantees and system of guarantees. Regulation of provider organizations' ethical standards serves precisely this purpose. Firstly, it establishes a moral infrastructure, ensuring that process reflects fairness, inclusivity, and respect for the dignity of all participants. And from jurisprudential standpoint, mediation ethics perform both a normative and social integrative role. When mediation institutions adopt and enforce ethical frameworks, they institutionalize social trust, transform individual ethical behavior into systematic and system accountability. In this sense, ethical regulation becomes a medium and mediator between mediation mediums through which the mediation fulfills its broader social purpose, preserving social cohesion and enforcing confidence in adversarial justice. I will sum up my presentation to the extent that the functioning, to summarize, the functioning of ethical standards in mediation may be conceived on two levels. The individual level of the mediator's professional ethics, which encompasses code of conduct, boundaries for decision making, and principles for managing conflicts of interest, and so on. And secondly, on the institutional level of ethics, which defines the internal policies of mediation service provider organizations, including the voluntary selection of neutral third parties, professional training and monitoring procedures, mechanisms for protecting confidentiality, and standards for handling complaints. Although ethical norms in the classical sense do not constitute a strict normative category, they nonetheless represent a significant source of soft law. The violation of ethical norms gives rise to professional accountability, indicating that ethics and law are mutually reinforcing and complementary categories. International practice recognizes a significant risk of inconsistent mediation and unfair mediation practices when authoritative organizations or state institutions operate without adherence to ethical standards. For example, in the process of case referral by mediation providers, it is crucial to ensure confidentiality, facilitate the impartial and competent selection of mediators, prevent the assignment of the majority of the cases to a single mediator, and prevent judges from receiving confidential information from mediation sessions could give rise to a reasonable suspicious of conflict of interest. Additionally, private providers' profit motives may create incentives for ethical concerns and compromises as well. Additionally, private providers profit for example, when referring cases to mediators, it is imperative to define whether and how mediation fees are distributed between the standing entity and the mediator. Failure to address these questions raises concerns about the neutrality and motives underpinning the referral processes. I think that speaking more precisely, there are several obligations that could become the policy recommendations for the regulative policy of stakeholders. The first is transparency is in mediator selection procedures, institutionalization of competence, verification mechanisms, strengthening informed consent, disclosure, conflict of interest management from the private and state provider organizations, enforceable obligations on accessibility and fairness of the process. It means substantial fairness and procedural fairness at the same time. Confidentiality as a pillar of integrity of the mediation process. One more recommendation could be ensuring procedural flexibility to address parties' needs, accountability, and continuous monitoring. As a conclusion, I may provide my presentation via written form, but I would like to summarize several major recommendations for stakeholders, for policymakers, and for regulative bodies who are responsible of institutionalization of mediation in the countries. First, policymakers should establish mandatory transparency standards for mediator selection procedures. Regulatory frameworks must require ADR providers to publish mediator profiles, disclose qualifications in a correct form, because otherwise it is a breach of rule of self-advertising, and ensure that parties can freely choose and replace a mediator before the process or during the process. To prevent commercial influence or structural bias, the introduction of neutral selection committees or automated audited case rotation system is recommended to be implemented. Secondly, regulators must institutionalize competence verification mechanisms, because quality of the mediation process is one of the key ethical requirements and guidelines of mediator ethical systems. This includes, second, regulators must institutionalize competence verification mechanisms. This includes mandatory professional training, certification, periodic reaccreditation and evaluation systems based on peer review, party feedback, and adherence to ethical norms, integration and extension of continued professional educational programs within the professional organizations. National standards should require that competence frameworks incorporate not only technical skills but also ethical reasoning, intercultural communication, and emotional intelligence and social understanding of the context. Third recommendation could be that legislators and courts should strengthen obligations related to informed consent, disclosure, and conflict of interest management. ADR provider organizations must be required to notify parties of any professional, financial, or personal relationships that could affect neutrality. Regulation should mandate written informed consent, ensuring that the process remains voluntary, transparent, and free from coercion. Fourth recommendation, the regulatory framework of mediation ethics should include enforceable obligations concerning accessibility and fairness of the process. Providers must ensure linguistic, financial, digital, and physical accessibility of the process, including fee waivers or reduced cost services for low-income participants of the process. They should offer some pro bono projects and services to the society. Regulators should require that ADR centers adopt policies preventing power imbalances and guaranteeing equal participation for vulnerable or less powerful parties in the process. Fifth recommendation could be to preserve the integrity of the process. Regulation must strengthen confidentiality protocols. ADR provider organizations should be obliged to implement secure data protection systems, prohibit unauthorized sharing of mediation information with courts or third parties, and train mediators and staff on confidentiality, nor clear sanctions for breaches are necessary to enforce trust. And it's vitally important to control what kind of information is transferred from mediator to the court after the end of the process. Furthermore, regulatory bodies should require providers to ensure procedural flexibilities that adapt to the parties' needs, whether through remote participation, online mediation programs, differentiated session formats, hybrid or on-site or off-site, or context-specific scheduling. Flexibility is a key component of fairness and supports effective engagement of the parties. Finally, national regulative system of each European countries must introduce robust accountability and monitoring mechanisms of the provider organizations. This involves mandatory complaint procedures, independent review bodies, publication of annual reports, sanctions for ethical violations, transparency of accountability of ADR provider organizations. Continuous monitoring ensures system-wide improvement, reduces system risks, and strengthens the legitimacy of mediation as a public-facing justice service. In conclusion, ensuring a coherent, enforceable, ethical regulatory system and framework for ADR provider organizations required coordinated, multi-stakeholder efforts involving lawmakers, courts, professional organizations, associations, and the providers themselves, private and public. The adoption of the above-mentioned policy recommendations will create a mediation environment characterized by transparency, inclusivity, accessibility, professionalism, and accountability towards the society. Such a framework not only protects the rights and interests of parties, but also reinforces public confidence in mediation as a voluntary, justice-oriented, and dispute resolution process, fair process, which has some cultural, legal, traditional dimensions, and part of the social economic system of values of the country. Ultimately, these measures will contribute to the sustainable development of mediation as an essential component of fair, effective, and liberal justice system throughout the countries. I think that I have used much more than allocated time. Thank you for your attention. And if society and audience would have some questions, I would be pleased and eager to refer to your interests in any direction. I suppose it's not the time for discussions, and thank you for your attentions. Me and Luisa often we are discussing the role of professional organizations and institutions and universities in regulatory policy, and I think that to some extent our countries will be ready from the perspective of legal policy and regulative policy to institutionalize these guarantees for the provider organizations as well. Thank you for your attention.
Дякуємо. Дякуємо нашим учасникам пленарного засідання, що
We are extremely grateful to all the participants to this panel for having actualized the existing knowledge and highlighted the most important aspects of mediation as of mediation in action. We are grateful for speaking about this scientific approach